All right, we're now live streaming. Good morning, everyone. Today's Friday, February 24th. This is our fourth voting list. We're going to start off with actually Senator West. Are we holding Senate Bill 21? Position of authority. Actually, that's Jamie's bill. Sorry. Sorry.
So let's do.
Where's Shamari? Oh, there's Shamari. All right. Where is, so let's start off with Senator West then. Senate Bill 210.
Oh, that's the.
Is that you?
So I can. So I didn't include, I'm sorry, I may not have saw that on the voting list. Senate Bill 210. Yeah.
How about?
Senate Bill 221.
So Senate Bill 221, that bill allows a court official or prosecutor to request that a person that posts personal information remove it and not post it again. On receipts, they must remove within 72 hours. An official may bring an injunction or an action for damages. A custodian must deny inspection of public records that includes personal information. There was an amendment that should be in your packet by the chair.
This is not my bill.
Which defines government officials to include the governor and lieutenant governor, as well as the former governor, former lieutenant governors. It replaces the word court officials with government officials and makes similar changes to court with government throughout the bill. I did it last night. Yeah, it's still in review.
Oh, the amendment is still in review?
Yeah.
The amendment is still.
Oh, it is.
The idea, discussion. Senator West. All right.
I have a note here to add county judges. Are we doing that?
That was my only worry about this bill is that it gets Christmas treed, because then everyone's going to want, oh, we need administrative judges. We need members of the House, members of the Senate, So I would probably suggest that we keep it with the lieutenant governor, the governor, and this judiciary man, if you want to move it. I mean, if not, then, you think we can hold off on people asking for things in the on the floor? I mean, it's going to be, the request will be made, but yeah.
I'm with.
Right.
Move on favor.
It's oof, okay. There's been a good. All right. That happened fast. That happened. Look, it's hold on. Discussion's open. There's been a motion. It's been seconded. We will honor that. But go ahead, Vice Chair Walsh, right here.
Yeah, so that's not where I thought this was going. So listen, my district is the district where the assassination attempt happened. So a gentleman from Florida, from California, who disagreed with the politics of one of our United States Supreme Court justices, flew to this area and with weapons and got to this, or rather, I think perhaps drove to this area with weapons and got to the street where the justice lives before making a phone call that allowed him to be caught. But what that triggered was an incredible disruption, not only to the life of the justice and his family, which, you know, in and of itself is, I think, important because his family didn't sign up for this, but also an incredible disruption for everyone who lived in that neighborhood with a surprisingly large radius. The July 4th parade that is on that street had to be moved. And to this day, there are consequences from that assassination attempt that continue to reverberate throughout my legislative district. And so simply shielding the addresses of our judges who have received these threats and continue to be in danger and at the forefront of very contentious decisions, whether those decisions are public policy decisions, as was the case with this justice, or just basic, you know, domestic decisions about custody and divorce and things like that, I think it's really important. And from that experience, I can't tell you how shaken my community was by what happened here, and it could have been prevented. This gentleman was someone from very far away, and he accessed the justice's address through publicly available information. All of that could have been prevented with something as simple as the law that we have in front of us. So I'm going to vote no on the unfavorable. I support the bill. I hope we can limit it if we pass it to the people that the chairman mentioned. And that's why I think it's really necessary to do this.
All right. Oh, gift of gab right there. All right. Go ahead, Senator West. I will say that we probably need to take a look at the language because it has, you know, past judges. It also has immediate family members. You know, like if your kids are living in California or you're here, you know, I don't know if it needs to extend to that level. But Senator West.
Would you want to hold it for a week while somebody works on it to?
It just doesn't. I think it's changed here.
It's like significant changes. Like,
Okay.
if you want to move it, if not, you can. I mean, we could. Someone wants to hold it. We can hold it. But
can make the change to just the affected position, not Senate and that's not the intent. The intent is to protect the person who serves in that capacity.
yeah, like I don't know how you fashion it, like or minor children that reside with you, or children that reside with you, or you know, children that reside with you, or
I think he's right. I don't think you have to specify.
yeah, or just your children. Sorry, Senator James.
I think we haven't put in minor children, at least that live with the adult. They have no capacity to protect themselves. They have no way of, got to go to school. They can't live elsewhere. So at least if we're going to provide that, I would strongly like to have minor children at least residing with
Minor dependent,
the adults that are being protected.
because like my nephew used to live with me.
You think you ever can, well, just, you want to do this on now, or do you want to, we've done this one.
Yeah, I was gonna just say that, you know, I appreciate the vice chair's comments and what a lot of our families go through that are in public service. And we all make pretty tough decisions around here, even in this chamber. And, you know, as officials and public officials, you know, we have we have to make tough decisions sometimes. And I think we go down a rabbit hole once we start shielding everyone's address. Our addresses are on the voting rolls. Our addresses are here. I just don't like how this can open up Pandora's box of having, who else can we block, like our police officers or our chiefs of police, you know, our sheriffs that do great work for us in our community. So I'm not a huge fan of this bill. I'll just say that.
I want to echo Senator Washington. My father was a parole and probation officer. I mean, he was dealing with the same people that judges are dealing with in the criminal justice system. His information wasn't necessarily shielded. I mean, I tend to agree. I mean, there's nothing in here that triggers it, except that their information is online and they want it not to be disclosed. I think once we start doing this, we're setting ourselves apart from everyone else. I mean, if this is some remedy that we want to make available for every citizen in the state of Maryland, I think it's something different. but that's not what we have in front of us.
Um, so, with respect to other family members, it seems to me if the family member is living with the judge and the judge's address is shielded, the family member's address is shielded. Maybe we can say immediate family member who is who's living in the same location as the court official. Get it that way. But if the judge and his spouse are separated, I don't think we need to shield the spouse's location. I know there's the question of mission creep here that's been raised, but judges are just different. You know, we all got ourselves into this. Well, you can say, yeah, but we have to have judges. We have to have judges. And so these are.
State senators.
So it's hard to articulate exactly why, but judges are different. This is a life vocation for a judge. You're appointed for 15 years. And you're doing a very important public service, which has to be performed. We've all elected to run for office. And so I don't put license plates on my car, which identify who I am, because I don't want to be flagging it out in public. But I just think there's a difference between judges and everybody else, whether probation officers or legislators or other people.
There's a motion withdrawn. I'll hold it. So we can work on some language, or if there's still unreadiness. I mean, I just said, there's been some really good points made about I personally think it's going to be a thing on the floor because people will try to Christmas tree this, which is fine. I mean, you can defend it, but you just fight it all. But I mean, look, we do have an address confidentiality program, which we tinker with from time to time. It's administered by the Secretary of State. It's for victims of stalking or domestic abuse. So, this isn't like a unprecedented thing. But I was thinking about this. Maryland Matters published an article about the governor selling his house. There's an address there. All right, go ahead, Senator Sidner.
I was just going to say the thing about that program that the Secretary of State administers. There's a trigger. These have been victims. That this is just saying your information is out there and you get the ability to have it removed. I don't think there's a trigger in this legislation of some sort of a threat. And I mean, if the testimony proves accurate, then there should be threats that are documented that the judges have had that I would assume they would then be able to if this was available to use. One other thing that makes judges a little bit different, when they go into their courtrooms, they have bailiffs. They can carry, I think I was told that we could carry weapons or whatever, but they certainly have a lot more protection than what we have as legislators. So I'm still feeling like Senator Washington, and not certain what I would do with this legislation.
So it sounds like we're going to hold this, but
Yeah.
let me just
Or kill it.
there was a judge in New Jersey, I think, a United States District Court judge, and her son was shot and murdered in front of her. And I don't think there was a precipitating threat. That was the judge who oversaw something related to the person who killed her son. But I don't think there was a mailed threat or anything that indicated to that judge that she was particularly at risk. And so if the argument that is that it should be more like domestic violence victims, perhaps people would be more comfortable with like an application. In other words, someone would have to fill out some paperwork and send it to the Secretary of State. But requiring that application to have a specified threat, I think is inappropriate because so much of the violence we've seen against judges has come without a precipitating threat. At any time, anyone who feels aggrieved by that judge can, and as we've seen, will act against that judge. And so I understand what you're saying, Senator Sidner. I just worry about the requirement of a specified threat.
Thank you, Mr. Chair. So he kind of took away my thunder there, but I just wanted to say that we're not talking about judges and protecting them from threats. We're talking about protecting their information prior to the knowledge of any threat, so that because we live in an age that everything is already documented, it's online, it's available. And if they make a threat, they probably already would have your information by then. So I think that it's a good measure to try to protect that class. And you know, I know we're talking about the Christmas tree effect, but if people have a justifiable reason to make a request, whether it be through the, you know, if we do it by modifying the language of the Secretary of State or for shielding, then maybe we just look at that language there, because it's put in, it's vetted for, and then there can be categorically we can have it available, but then it would be just incumbent upon them that it wouldn't be done automatically, that if they felt that their position in the community deserved it, you could do it. And that would also be for, you know, if somebody, you know, for this, I don't think it's correct. A judge knows what they're getting into. They go into that process, they volunteer for that. Yeah, they're not elected, but they're still an appointed privileged position, and it's a very important position. And I think we should, if this is what we need to have their address done, we should shield it and be done with it, because otherwise we run the risk of them being susceptible to undue influence, knowing that they cannot shield their information from someone and they're sentencing people to long sentences. So that should be a concern for anybody. So, and for the justice to unfold properly, I think it would be an important step. Thanks.
Mr. Chairman, I like the bill. I'm going to vote for the bill and I like you all, put all of you all in the bill if I could too, just to make sure you're safe. But on the other hand, I'd like to know, how would this be implemented? Meaning one can go online in any number of places online from so many sites. My address is there, your address is there, phone numbers are there. I mean, how do you notify all of these places? I pull it up and it just comes up. He lives here, he lives here as many years and blah, blah, blah. It's all out there. So how would we implement this to make sure it's effective? And that's my hang up, is would it be effective?
Folks that are shielded, like our chiefs are shielded at times, and they won't show up on the voter poll, the voter file or anything, and you can look that up anywhere. There's other places too where stuff is shielded too.
Only if it's requested. Gotcha. So the judge makes a request like, hey, I need the public list, and you refuse. In your the mere publications.
Violation as drafted.
Yeah. So let's we're gonna hold it. I think we can refine the language to limit it to the people that it applies to, and then we can get some more information from, like, the Secretary of State can provide us with information how that works in terms of removing you from the voter file, the voter rolls, and just so people understand how it works.
28 minutes, one hold, 23.
There you go. That's JPR style, man. That's how we do it. All right. And we've already, talked about this bill before, but all right. All right, Shamari, we're gonna go Senate Bill 253.
So Senate Bill 253 requires a register of wills to accept any document electronically except an original will that is filed electronically through a system established by the register in accordance with the Maryland rules. It does not, however, prohibit the filing of a paper document.
Second.
So motion for a favorable has been seconded. Is everyone okay? All right. The bill passes. All right. Senate Bill 253 passes. All right. Shamari, what else do we
I
have?
can go back to 210. I got my paperwork.
Let's go to, so Senator West, this is a Senate Bill 210.
Senate Bill 210 alters a prohibition on judges of the Orphans Court from acting as attorneys to prohibit a judge or to prohibit an Orphans Court judge from acting as attorney only in matters related to the administration of an estate or a guardianship of a minor. There is an amendment which adds that Orphans Court judges would be prohibited from practicing in cases that were related to the preparation of an estate plan or estate planning documents that might come within the jurisdiction of the court in any county or Baltimore City following the death of an individual.
So this is a simple bill. This is the Estates and Trusts article of the Maryland Annotated Code. Look how thick it is. And in this is some of the most abstruse language in the entire code because it dates from medieval England. Things like the rule against perpetuities, which most lawyers don't understand. The idea that laymen are going to try to deal with this and deal with it correctly. We need lawyers on the orphans courts who can understand this stuff. So right now, it's a hodgepodge. There are three counties in which the judges of the circuit court act as the orphans court: Montgomery County, Howard County, and Harford County. In all the other counties, we have a lot of lay people serving on the orphans court. Right now, in most counties, it's a part-time job and the pay is insignificant. It's like $10,000 a year. So in most counties, if you're a lawyer, you have to stop practicing law in order to serve on the orphans court, which no lawyer is going to do. So what this bill says is you just can't practice the kind of law that'll come before the orphans court. You can practice all the other kinds of law you want. And I think it's a great idea. It's going to get lawyers on the orphans court who can understand this stuff. So they do it right. So I think it's a simple bill. There's no opposition. I move favor.
You want to move your amendment first? All right. Can we adopt the amendment? All right, everyone's good with the amendment. All right, now the bill's before you as amended. Motions for favorable. It's been seconded. Everyone's okay? All right. Senate Bill 210 passes with amendment. All right, Shamari, we'll stick with you. What else do we have? Senator McKay, Senate Bill 277.
So Senate Bill 277 requires the judgment creditor to provide notice by certified mail and first-class mail to certain persons regarding the time, place, and terms of the sale of any real property, subject to a sheriff's sale at least 20 days before the property can be sold, and to file an affidavit that the individual has provided such notice. It allows the sheriff to use the assessment of record in lieu of an appraisal. It also establishes that a sheriff's sale of real property extinguishes subordinate liens on the land being executed if the requirements of the act are met and the judgment creditor has applied with any applicable rules. There's two amendments. Amendments 913724 deletes from the bill the ability of the sheriff to use the State Department assessment and taxation assessment in lieu of an appraisal. Amendment 443021 deletes the notice requirements of the judgment creditor and leaves the notice with the sheriff.
How many amendments are there?
Two.
Do the first amendment.
44302.1/1. Can we just
Yes,
explain
so
that?
that amendment deletes the notice requirements that were placed on the judgment creditor. So the only notice will be a 20-day notice provided by the sheriff.
So what was the second notice that was pondered in the bill initially? Is another 20 days or what was it?
It was 20 days before the sale. So in the original law, it was notice provided by the sheriff before the sale of real property. The original bill language required the judgment creditor to send notice to all interested parties, all subordinate liens, and make efforts to make sure that they were notified of the time and place of the sale. This amendments will delete all of those requirements. And so the only notice that those
20 days before sale.
potential subordinate liens would have is the sheriff's notice.
Senator Reese.
When we say notification, what does that mean? Does that mean email only? Does it mean certified? I thought I saw certified
So-
in there.
Yes, so time placed by certified and first class mail to the owner of the property and the holder of any subordinate mortgage deed of trust, subordinate interests, including a judgment.
And none of the amendments strike any of that.
Strikes all of that. And so this amendment 443 just takes all of that out of the
And it
bill.
takes notice to what?
Notice as was originally in the law to the sheriff, 20 days. And so
So you
The
just mail, you can just send an email.
no, well, the sheriff may provide notice in that way, but it can be posted on the courthouse door, bulletin board in the vicinity of the door, printed in a newspaper. And so that's how the law
This has
was.
to do with blighted property.
Right.
That's exactly correct.
And
There's
and I'm
not a
sorry,
real
but
direct
pardon me.
path to getting the title of this blighted property. Not trying to take away from people. This is,
No, I got
this
you.
is abandoned.
And pardon me, but blighted property is determined, it's abandoned and it's, I mean, who determined what is blight? I know, but
Well,
if
this
you
is,
own a property and you say, hey, it's, and that's not.
right, but you're going to be dealing with the city officials at that point. I mean, this is the last effort of trying to deal with this, so.
Who's
So all
What?
the amendments
yeah.
Take care of anybody who was, no one testified against it, but there were two different groups that said, hey, we would like some amendments and then we're okay with the bill. And both of the amendments take care of that. That was SDAT and Shmari, who was the other? I forgot.
Just because they didn't want to do the
Attorney
written.
General.
Attorney
Right.
General.
Okay.
Attorney General?
No, I'm sorry.
I don't think AG is gonna be like, let's notice.
Believe it was the Creditors Association. I forget which one, but it was in the interest of the creditors who did not want the onus of. Yes.
Correct.
All right, let's take the books and.
Which strikes the notice provisions. What's your is there a motion on that or?
443021.
Yeah. So moved, seconded. Is everyone okay adopting first amendment? The notice provision, the repeal of the second notice provision? Okay, now let's look at amendment 913724/1. Shamari, can you explain?
And so 913724 deletes from the bill the ability of the sheriff to use the SDAT assessment in lieu of an appraisal.
So how the property gets that? Sheriff would then get an appraisal from a real estate agency. Historically,
SDAT, assessments have never been used as appraisals. That was their issue.
Senator James.
Is every 3 years?
Every 3 years.
3 years. And Mr. Poirier, what do you want to do with the amendment? Is there a motion? Move favorable, it's been seconded. Is everyone okay adopting the amendment? All right, now the bill is before you as amended. Senator Washington.
Yeah, just a question because I'm very new to this subject matter. Does this apply to all sheriff's departments? Does all sheriffs do this throughout the state?
Yes. Yeah, so if, during the, so the city of Frostburg came in as well as the city of Cumberland. They have problems with blight. And this is gonna take the sheriff sales in search of the titles. It was bare bones and vague about how the process was. This is gonna shore this up, giving them the ability to get to the title.
Got
And
it.
so it is a statewide.
Okay, cool. Thank you.
There, but, all right. Now, bills before you as amended. Is there a motion? Motions for favorable. It's been seconded. Is everyone okay? And the bill passes with amendments. All right. Shamar, let's go to Senate Bill 808. Oh, is it withdrawn? Oh, geez, never mind. Actually. Yes. All right, so the last three, we can just do this right real quick. Senate bills 484, 704, and 808 are all withdrawn. So the motion is for a unfavorable withdrawn. So everyone seconded, everyone's okay? All right, Shamar, do you have anything else on the list? 100 is being held, right? Yeah. All right, so we're gonna hold 100. And you've got Senate Bill 106. Senator Sidnor.
Senate Bill 106 exempts $500 in a deposit account from execution on a money judgment. This is inclusive of the $6,000 exception that a debtor may exempt from execution. As amended, the bill adds a definition of depository institution. And it would clarify that the $500 is to be included in the $6,000 total that a debtor may elect to qualify. It also clarifies that a depository institution may not be held liable for good faith reliance on instructions in a writ of garnishment. And it establishes procedures that bank institution must follow on receipt of a writ of garnishment or attachment or levy. The amendment also essentially prohibits the bank from garnishing an account more than one time, and essentially establishes that the depository institution can apply the garnishment as they choose if there are multiple counts, and that the garnishment or that the exemption, applies separately to each institution that the debtor may have.
Right. The whole point of the bill was trying to ensure that people had a certain amount of money left in their accounts. I know last week's conversation, there was a question about or some concern about the look back or the snapshot provision. I mean, honestly, I'm for that particular provision, I'm not married one way or the other. So I mean, if the committee wants to move that way, I don't think that's an issue. Am I correct? The whole snapshot thing, that's not, your client was more concerned with just making certain that they were protected from liability, right?
So the snapshot, about half the states have a snapshot, half the states have a continuing garnishment. Under current Maryland law, when a judgment creditor wants to attach money in a bank account, it goes typically in district court. That's where most of these cases are. And it seeks a writ of garnishment. That writ of garnishment gets served on the bank. The bank then looks at the account and answers the writ and indicates how much money is, in the account that would be subject to garnishment. For instance, it knows that this amount of money was deposited for was direct deposited for Social Security. That's not garnishable. The bank answers that, and then the judgment debtor has the ability to come in and contest it and ask for a hearing. Doesn't happen very often, but it can happen. What happens in most cases is if there's money in the account, the judgment creditor, after the time expires for the judgment debtor to answer and contest it, they seek then an order of court as ordering the bank to remit the money that's in the account. What the snapshot does is the snapshot, once again, I think Pennsylvania, a number of other states have it. Snapshot says that you look and you what's subject to garnishment is what's in the account when the bank gets served with the garnishment. Maryland is a continuing garnishment state, and what that means is that every time, if more money is put in the account, that money then becomes subject to the garnishment. Now, it's burdensome on the bank because if that happens, the bank then has to go back and re-examine the account, figure out what's exempt and what's not exempt, keep track of it, keep part of it frozen, and another part of it isn't frozen. So when we looked at this bill, we looked at it in two capacities. One, we had our garnishment hat on. The other is we're often judgment creditors. So we looked at it both ways. But I think from the point of management of the account, the snapshot is much less burdensome on the bank. The bank hasn't done anything wrong. It's just holding the money. One of the benefits of the snapshot is for the consumer is that consumers don't they get this legal form from the court. They don't understand what it says. They don't understand how it works. They don't understand what it means. Should they put more money in the account because, which nobody had understood it would do, right? But it's going to be subject to garnishment. That's going to get taken. In addition, what happens if many of us, I don't know about the people in this room today, but even for me, my paycheck is direct deposited by my employer, by my law firm. And the judgment debtor needs to then understand that if he doesn't contact his employer and let the employer know, don't put any more money in that account, his wages are going to be subject to garnishment as well. So, balancing it all out, that's the issue. The other thing that the amendments do, which we're fully supportive of, which the consumer advocates are supportive of, is just making it clear the bank has no idea what exemptions have been claimed by the judgment debtor at all. We don't know that. The only person who knows that is the judgment creditor and the judgment debtor, what exemptions have been claimed. So the other concern is that, and no one has a problem with this, is making it clear that the bank goes ahead and freezes money and remits money that's in excess of the statutory exemption cap on a judgment, which is $6,000. And that'll be the 500 plus the 6,000 at this point. The bank's not going to be liable for that because the bank has no way whatsoever of knowing. We tried to work with Judge Marcy and talked last year. This is like the third year this bill's been in, to talk about trying to change the form to make it more consumer friendly. So that's the explanation. I think.
Okay. All right. So my concerns on this was the snapshot. Senator Sidnor and I had a good discussion about it. He seemed amenable to removing that because it is an unfair balance and it costs the debtor each time to go and collect it. There's a process and a fee, and they won't know if there's $300 in the account and they've now wasted their money to try to recover some monies, or if there's $512 in the account. The other issue is that I thought about is, how does this work if the person decides to have multiple accounts and they do distributions to those multiple accounts through direct deposit? Say I get paid $1,500 a month every 2 weeks. If I say I want 500 to go to my savings, I want 500 to go to this checking account, and I want 500 to go to this checking account in the same institution, they would see holistically that they have more than that. But my understanding is, by the way this is written, it's per account, so they wouldn't be able to garnish or recover their debts at all. Is that accurate?
No, I think that when the bank is served with the garnishment, the bank is then going to report what is in any account in the judgment debtor's name.
I understand that, but if any account is 500 or less by this bill, you can't garnish the funding. It doesn't matter that it's all under the same person. It was by account.
No, I think it's by judgment, not by account. The $500 is by judgment. It's an exemption against, the exemptions are per judgment, not per bank account.
Are you saying that if you have more than one account with the same financial institution?
Yes.
Yeah. So the question then is it within the institution or is it within two different financial institutions? Let's say I have Bank of America and I have Navy Federal.
Yeah.
So I think his scenario deals with what I just said, like maybe two different financial institutions. But the question then is, what if you only have one financial institution that you bank with, but you have
Correct.
several accounts with the same institution? Does it cover that scenario or is it just two different institutions?
It's the exemption, my understanding of the $500 exemption, like any other exemption, is it's not per bank account, it's per judgment. So if you have 3 accounts of the
Mhm.
same bank
Mm-hmm.
and the garnishment hits the bank, the
Mhm.
bank's gonna report what's in those accounts.
Okay.
When the day it gets all
Okay.
3 of them. And the money in all 3 of those accounts, if they're all titled in your name and you're the judgment debtor,
Okay.
are gonna be subject to garnishment. And that exemption, that $500 exemption is per judgment. So if let's say the 500's automatic, and then when the debtor has been served with the garnishment, the debtor goes ahead and the debtor claims exemptions, let's
What-
say there's 3,000 in all the accounts together. He can claim $3,000 in exemption, and that applies across the board to
all the accounts. Okay, but the issue with having multiples at other places would be a way to obviously circumvent this.
Oh, look, if I'm a judgment debtor and I'm worried that my bank account's gonna be garnished.
You
then,
start spreading it
I
around.
have multiple bank accounts. The garnishment only applies to the bank. that
So,
serves
and
the-
for those reasons is why I'm even more against the snapshot.
I hear you.
Thank you.
Or is it just one amendment? Just a-
I would say this, Mr. Chairman, that if you take the snapshot out, you take it out, but the rest of the amendments, I would urge the committee to adopt them. They don't affect it one way or the
I
other.
think you're fine with the other amendments, right? So Senator West, go ahead.
So let me talk in favor of the snapshot. So from the point of view of the debtor, of the consumer, the debtor, they don't know what's going on. All they know is they've gotten some legal document from a court. Most people have their paychecks direct deposited into their bank accounts. And most debtors who get this legalese from the court will have no idea that unless they tell their employer not to deposit their check into that bank account, their wages are going to get caught up in this garnishment. And so the bank is going to freeze everything that's in the account on the day that the bank receives the garnishment. And then when the next paycheck arrives 5 days later, they're going to freeze that too. And when the next paycheck arrives 14 days later, they're going to freeze that too. There's nothing letting the consumer know. And if the consumer was smart, he would find another bank in an obscure part of the state and open an account there and have his wages deposited into the bank. But most consumers are not smart. So the idea of the snapshot protects the consumer because the bank would have, the creditor would have to file a second garnishment to get the money to get any additional money that later on arrives in that bank. And presumably by about that point, the consumer is going to figure what tactics he had to pursue in order to protect himself. So I think frankly, the snapshot protects 99% of the consumers who otherwise would allow their wages to continue to be deposited into that bank where they would be frozen.
They're left with $500 available to them. Is that correct? So the purpose behind this is to still give them access to not take all their money, but keep $500 so that they can still function and have a livable opportunity while they settle this issue with the debtor. That's why it doesn't freeze all their monies. It still gives them $500 per institution that they have money in. Correct.
Yeah, so if 4 or 5 days later, the next paycheck is put in, 500 has already been saved by the bank, protected. that whole next paycheck gets frozen. Right? And then
Provided he
2 weeks
hasn't,
later, the whole next paycheck gets frozen.
provided he hasn't spent any money, it's always gonna hold it up to at $500, and then anything above that goes towards the repayment.
Right, right.
Right.
And so most debtors, most consumers are not going to know this system, and they're not going to take a step to prevent more money from being put into that account. And if more money is put into that account, that money gets frozen. And ultimately
And
goes,
why is it frozen?
because that's.
There's a judgment.
But if we do not have a snapshot system, then until the garnishment reaches its end and the court enters the order, the bank freezes everything that comes into that account, right?
And why is it being frozen? Because there's a debtor
Because it's a
making
debtor and
an
a creditor.
collection,
Right. I'm not-
an
I'm
act
not
of
saying they don't
collection,
owe the money. They
collecting
owe
of
the
a debt.
money.
They owe. I understand that. I understand that, but I'm just saying, we're making it like we're freezing. We're trying to, we're trying to make it seem like we're unnecessarily or harming people by freezing their money, but there's a debt that was made. There's an action that's being made to collect such debt because they're in default of that debt. So this is, I mean, by that rationale, we would just let everybody keep running up their debt and never have to worry about collecting on their debt, because if you don't pay it, oh, don't worry about it. They're just, we're only going to get a snapshot every once in a while and be done with it. I just think that's wholly unfair to those that are extending a line of credit or some type of good faith measure that you're going to repay, and then you just default on it and don't pay your debt back.
I would just say we didn't have a hearing, a real policy analysis of whether we should go snapshot or continuing garnishment. So suddenly a very smart targeted bill that I think we all agreed was a good idea. Now we're getting into a much larger issue where I would like Bob and maybe some other organizations that can weigh in on whether we should do this larger issue that I'm uncomfortable either way on this, making the bill bigger than it was, because I think it's a great bill as it was originally brought in with the minor amendments that don't deal with snapshots. That's my suggestion.
It's Senator Meadows, so let's do this. So then,
The two parts of the amendment, one is to absolve the institutions for not being aware of how much money is in every account. And then the second part is the snapshot. So it seems like it's the will of the majority of the body to just take the first part, not the second part. So not the snapshot, continuous evaluation, not the snapshot.
Let's take out number 3.
Yeah. Was it number?
Number 3.
Yeah. So if you look at your amendment on amendment number 1, it's number 3, take out number 3. Is that right, Senator Sidler?
Correct.
Okay. Does everyone understand what's before is everyone okay adopting that? Is there a motion? Is it seconded? Everyone's okay with that? Okay. Are there any other amendments to this bill? All right, so now the bill is before you as amended. It's been favorable. It's been seconded. Is everyone, all right, excellent. Snapshot will be another bill. I guarantee you that'll be another bill next year.
Thank you.
Thanks a lot. Thank you for that. Thanks for your help. All right, Shamar, are you done? Is anyone else?
56.
56, which one was that?
Yeah, prohibited down to 18.
So I'll report that next week.
Yeah. All right. Let's do Senate Bill 37.
Thank you, Mr. Chairman. This bill shortens some of the waiting periods for filing a petition to expunge criminal records. The bill establishes the following waiting periods for filing an expungement petition following the
Senator
petitioner's
Carter, go ahead.
satisfaction of sentences imposed for all convictions for which expungement is sought. This would include parole, probation, and mandatory supervision. Those time periods are as follows: 3 years for a misdemeanor in general, that is currently at 10 years. 5 years for second-degree assault or common law battery, currently at 15 years, and 5 years for a felony in general. That expungement for a felony is currently at 15 years. I would note that the bill retains the current 15-year waiting period for domestically related offenses. There is one amendment in your voting packet. Essentially what that does is anywhere in the bill where waiting period was being shortened to 3 years, the amendment would take that to 5 years. And anywhere where it was 5 years, it would take it to 7. So it's increasing the time period from what the bill had been lowering it to.
So we're taking what would normally currently be a 15-year expungement on these serious
Assault 2 and battery is 15.
a serious assault and battery, or assault 2, or not assault battery. We don't use that anymore. And we're reducing that to
Well, under the amendment,
7?
it would be 7, correct?
And then, okay. And what was the ones, I'm sorry to ask you like the field of this, because I don't have it right.
Please.
But what was the thing, what are the types of offenses that we moved down to 3 and 5 then?
Nothing would be at a 3 with the amendment. Misdemeanors would be at 5. So and then felonies would be at 7.
Yeah, I mean, we're gonna take felonies and go down more than half. And what were the misdemeanors before? How long?
10. And just to clarify, that's of the list of enumerated misdemeanors. There's a long list.
Yeah, I understand. Not
Right.
just any misdemeanor, but
Correct.
the enumerated ones. And then we're still leaving domestic related offenses
At 15.
at 15 with a lifetime ban of being able to, or at least during that 15-year, well, no, a lifetime ban of firearm possession.
Yeah, and it's interesting. I recently spoke with state police about the effect of expungement on firearm possession.
Yeah.
It's actually an issue that I'd like to dig in a little bit deeper with them on. But
Yeah, that's what
they had informed me that apparently Maryland's expungements don't restore
The
ability
right
to possess a firearm.
Possess a firearm. So if that's the case, why are we leaving those offenses, which, as I understood this bill to be brought forward, was for employment purposes to be able to continue on with your life after these type of offenses? Why are we still leaving a domestic battery charge that has no bearing on their ability to, whether it's expunged or not, to possess a firearm at 15, but we want to take someone that's involved in an aggravated first-degree assault with a firearm, one of them, and then we're going to lower that to 7? I'm just asking because I'm kind of asking for a friend here, because I don't understand the wisdom. I understand the wisdom of what we were trying to do when we passed the protection for domestic violence offenders. I understand that. And if they're saying that it doesn't, and again, I would ask about looking into the expungement as well. But if that's the case, and that's not the intent, are we not causing potentially a greater harm for the person involved in the domestic situation that has a family from, kids in common with that estranged spouse, to then be able to be in a position to improve their life and provide for the kids that they owe child support on?
Well, that's certainly the committee's prerogative.
Open piece, like for the prohibited person, I mean, I know that's kind of an open question, but that's probably not within the state of Maryland's ability to do that. That's because those are federal database.
Right. And, again, I sort of indicated that that's an issue that I was actually a little bit surprised by, because I had been under a different impression previously. So, moving forward, I had intended to dig into that with them, but yeah.
That's
right.
what I'm saying.
I couldn't say whether or not you would.
Yeah. Senator Walsh-Reagan.
So just to clarify, I don't think first degree assault is expungible. And so I'm looking at,
I'm gonna have to double check
So-
on that real quick, Senator, but,
so here are the felonies that I think are expungible under current law. And tell me, I'll rely on counsel here. A felony that is a violation of 7-104, the criminal law article, that's a theft scheme. The prohibition against possession with intent to distribute a controlled dangerous substance under 5602 of the criminal law article. 6-202A, that's first degree burglary, 6-203, that's second degree burglary, and 6-204, that's third degree burglary. And then any attempt, conspiracy, or solicitation of the offense listed in item 1 or 2 of the subsection. So my understanding is that Justice Reinvestment, which is the group of legislators, including many of the people here today, that created the expungement list of offenses, were focused on non-violent felonies, and first degree assault would be a pretty violent felony. So I don't think first degree assaults are covered unless I'm missing anything in the felony list here. Correct.
right. So, yeah, I'm looking at the list right now, and I do not see, first degree assault on that list.
Thank you, Mr. Chair. And yeah, I appreciate this bill, and I think it's actually a good bill. I see in here our state's attorney from Prince George's County has a potential amendment that they wanted to add about there's been just a lot of deaths from either auto or deaths period in our county and around. And in her testimony, she indicates that lowering the number from, I believe it's 15 to 5 is too low. And then also just because the effects that it has on victims themselves from these deaths that occur. And I know we move in at up to 7 through this amendment right now. And she's concerned that it sends a message that we aren't taking these things seriously when it comes to deaths. I think that I'm kind of in agreement with her a little bit to send a strong message, but I think 15 is a long time too. But I just think that 7 still is a little low, so. Is 7? Is that 7 now in the amendment?
In the amendment, it's 15 now. Yeah, so.
So, so the input of the state's attorneys, including your state's attorney, is why the amendment is in. And so I think, so the original bill takes felonies from 15 to 5 and misdemeanors from 10 to 3. And the state's attorneys came in and said, listen, we're generally supportive of this idea. In fact, everything that's in this bill was agreed to by the state's attorneys originally as part of justice reinvestment. In other words, this list that we have here was agreed to by the state's attorneys when we did justice reinvestment. So this is their work product. But I think they came in and said, listen, these numbers are a little bit too small, and let's bump it up. And that's why how we got to 7 for felony and 5.
The last thing I'll add in here is she says we also suggest that efforts to expunge records not be allowed unless any orders of restitution have been paid.
That's right. And so, and that's a subject of confusion within the judiciary right now. So the point of the bill was not to change current law.
Good.
And so the current law as written is slightly ambiguous as to whether restitution should be required. What my understanding is that is happening for those who cannot pay restitution, their judgment is transitioned into a civil judgment for the victim. And then the expungement is allowed, and then the civil suit continues to exist. And so that money is continued to be owed by the perpetrator to the victim.
Last question for this bill. Is this retroactive? So if someone they're at year 5 or 6 right now, could they next year have it expunged because of this bill?
I think the answer to that question is yes.
Okay, cool. Thank you.
Thank you, Mr. Chair. Just kind of piggybacking on what Senator Washington was saying. You know, he brings up a point about auto thefts and people feeling violated and unsafe. But, you know, I'm going to go back even a bigger step. And I don't know how many of you have ever dealt with a victim of a crime where their home's been burglarized. but it's an invasion of their privacy, and it is long-term rippling effects for them not feeling safe in their home. They feel violated. And for us to just go back and kind of say, well, 7 years is long enough from 15. I mean, I would be amenable to 10 years, but that's an extreme invasion of one's in violation of their privacy. And people know that their homes have someone else has been in their secured home. And you dealing with the victims of this on a continuing basis, I can tell you that 7 years is wholly unfair to those victims. And so I would be amenable like 10 years, but I think going from 15 to less than half to 7 doesn't send any message except that, hey, we're sorry your house got broken into, or we're sorry your car got stolen, but as long as they go out and buy one and pay their 6-year note, I mean, they should be able to get out of it then, but that's one car owning payment program, basically. So I would be against this unless we're looking to potentially amend it to 10 years, and then I could, wrap my brain around in support of that with that issue alone.
Thank you very much. I understand what my state's attorney is saying, and I understand the 7, the 10, 15. So I'll be amenable if you wanted to have a motion to make it 10 years. We just move right on with that if everybody's in agreement. Because it kind of satisfies what our county executive is saying. I understand that, and it kind of brings a pretty good compromise. Would that be acceptable?
So just on the technical side, I don't know if Senator Washington was referring to theft of autos or theft from autos, but Senator Folden mentioned theft of autos. So I don't think theft of an automobile is covered is expungible under the bill.
I probably misspoke that.
Okay.
But anytime someone's safe space, whether it's their car that they feel they have a safe area in, or their home, anytime that curtilage is violated, they carry that for years beyond that, being unsafe, because then their next worry is, what if I was home? They don't know that maybe someone was watching and waited for them to leave.
Yep.
Their next concern is, what if I was home? What would I have done? What would have happened to me? And they start really they struggle with that. And I think we need to remember, I know we're doing these things to kind of allow people to have this redeeming qualities and redeem themselves, but there needs to be consequences for these purposeful, malicious actions that put the public in fear.
Absolutely. One last technical thing, and then I'll defer to the chairman. So just so you know, this is not automatic expungement. The expungement of these more serious offenses through the Justice Reinvestment Act requires a petition, and that petition is a hearing at which the state's attorneys can object to the expungement. And so this is not an automated process, and it is not a non-adversarial process. The state's attorneys under current law for the offenses listed here always have a right to object to the expungement. And the judge has the ability to deny the expungement if the state's attorneys object and make a good case in front of them. And so I agree with everything you said, Senator Folden. I just want to be clear, this is not create an automated process by which burglars somehow get away with it. If a state's attorney believes, as you do, that it's not an appropriate remedy, they have the ability to say that in front of the judge.
I guess, and one last question for clarity, and I apologize. I think this is obviously from this would start, it's not from the date of the offense, but it would be from their date of completion of the sentence. Like Mr. Coleman, who was here the other day, he was talking about he's been 13 years or whatever. So he and I have had some great discussions. I just saw him yesterday over in the House. He was testifying on the same bill. And I just think that, like I said, he understands that he is erring in his ways, and he's here advocating for us to, consider these. He doesn't say that there's not a penalty that should be there beyond that. He understands that for his actions. He takes responsibility for that. And that's the type of people that I want to have coming in and requesting this to be removed so he can continue to advance through his life and move on beyond this, because I don't want to hold people in purgatory or in perpetuity for an offense that they made as a young man. But there's got to be consequences with it beyond the service of their sentence for the safety and comfort of the public. Thank you.
Well, I was just sort of going back to Senator Washington's comment about his state's attorney, I guess unauthorized removal of property is a offense that's expungible. It's a misdemeanor, and it would include removing without permission something including a vehicle, motor vehicle, vessel, livestock. So that would be like a lesser of the I think of the statute on vehicle theft.
So we're gonna hold it because I want, Senator Washington, Senator Walstreicher, maybe Senator Muse to work together, Senator Fold, we want just to talk, but then also for, not to add more work for you, council, but for me personally, I'd like to just have an enumerated list, because I can dive through the code here, but it's, yeah, you're looking at me like, but
I got it.
okay, good. I think I need to be eyes wide open when we go to the floor on this, so.
Thanks, Mr. Chairman. Yeah, the list actually exists, and I'll get that to you guys.
Thanks. Just so we're all, because it will come up on the floor. All right, Tuesday it is. Let's do Senate Bill 15, and that's Josh, right?
Senate Bill 15 requires that if a complaint is filed with a Department of Juvenile Services intake officer alleging that a child younger than 10 has committed an act that resulted in the death of a victim, the intake officer must file a petition with the juvenile court alleging that the child is in need of supervision. So you have an amendment in your packet. This amendment would additionally require that law enforcement officers who have knowledge of such facts forward the complaints to the Department of Juvenile Services intake officer. It would also raise the age in the bill from under 10 to under 13. And it would make some tweaks to the language to specify that the resulting petition could be for delinquency or child in need of supervision, because an 11 or 12-year-old child could be subject to delinquency jurisdiction.
From my discussion and my understanding of the amendments, I think the amendments make the bill better. I do just want to clarify that the discretionary part of the option to either file delinquency or sins applies only to those cases where there would have been the charges anyway.
Correct. So it doesn't create any additional delinquency jurisdiction for the court.
Well, we'll work off, we'll adopt the amendment first. Amendment 403324/1. Is everyone okay adopting the amendment? A motion for adoption and seconded, everyone's okay? All right, so now the bill's before you as amended with the inline version. Further discussion? So motion's been favorable, it's been seconded. Do we need a roll call or is everyone all right? All right, the bill passes unanimously. That might be, I don't know. All right. Excellent. All right, so Josh, we're gonna go Senate Bill 209.
Thank you, Mr. Chair. This bill establishes the task force to study crime classification and penalties. The task force must study specified issues regarding the classification of penalties for criminal and civil violations in the state and make related recommendations. The Office of the Attorney General provides staff for the task force, and the task force must report its findings and recommendations to the Governor and General Assembly by December 31, 2024. The bill takes effect June 1st, 2023. There are 4 separate amendments in your voting packet. I'm going to start off with amendment number. It should be the first one you see there for 209. It's 753925. That's amendment 753925. This alters the membership of the task force. So if you'd like, I can just run down the list. It's one member appointed by the chair of JPR, one by the chair of Judiciary, the Attorney General or designee, the president of the State's Attorneys Association or designee, public defender, and the following members appointed by the president of the State Bar Association, one member of the State Bar with expertise in victims' rights, and one member of the State Bar who is a member of the criminal law section of the State Bar. Chair is appointed by the chairs of JPR and Judiciary, and then if you turn to the last page of the reprint, it alters the scope of the task force's work, and requires the task force to study and make recommendations regarding a method for classifying crimes and civil offenses under state law. So this would basically, the role of the task force would be to identify just an organizational structure that that they would recommend to the General Assembly to move on from there.
I think this is okay. It substantially, the membership is fine. It substantially reduces the task of the task force for this task force, but it tees up the next task force, which will be to take the structure and then to evaluate all the various crimes and put them in logical places in that structure.
Yeah, I think that's good. I think it's a good approach because then if you have both of them at the same time, doesn't, I mean, it gets not political, but then it gets, you're talking about real policy decisions in that sense, you know what I mean?
Right.
It would be good to have a structure first and then have that second part discussion, which is going to be a lot more messy than the first part.
Right.
It's been seconded. Is everyone okay? All right. Jamie, we have two additional amendments.
You do. The next amendment, actually, Senator West,
What I want to propose, but I'll do it at the end. You go ahead.
Okay. That sounds good. So this one, it alters the scope of the task force's work. If you turn to the last page of the reprint, and this is actually in line with what Senator West had just mentioned, shall identify and logically categorize all crimes and civil offenses that exist under state law. So it's whereas the last amendment had the scope of the task force working on what is the structure generally of how crime could be organized under state law. This gives them the task of actually taking crimes and just categorizing them into well, logically, however that would look.
Yeah. So the idea here is if the structure is property crimes, it would take all the crimes and in the code that fall in that category and lump them in that category. So in some future year, different task force can actually look at all the property crimes and try to figure which are the oranges and which are the apples to make sure, my phrase is to make the punishment fit the crime, to be logical in making the punishment fit the crime. That's the work for a future task force. This would simply establish the structure, including property crimes, and then take all the crimes in the code that fall into that category and drop them under the category of property crimes. Yes.
I just think it's interesting and funny that you reference a future task force, because in light of the other discussions we've had recently around expungement, I actually think that the future task force, as they look at whether the punishment fits the crime and try to bring some type of sense to how we classify crimes and how we punish, there probably ought to also be a look at how we select expungement in times too. I'm not saying anything, but I'm saying like we're all over the place. We got to get it together in a more uniform way.
That's a very positive suggestion. And so when we get to the following task force, We should think about including expungement in the discussion of how making the punishment fit the crime. So let's make the expungement fit the crime too. It makes sense, but that's not this bill.
All right, seconded. Is everyone okay with the amendment? All right. How many more do we have?
We have two more.
Plus Chris, another one. Okay.
The next one, 783-228, pertains to the membership of the task force. This would include the executive director of the Maryland Network Against Domestic Violence, or designee, and two representatives of the Maryland State Bar Association, designated by the president of the association. So that.
And so what other members? Is it?
Well, so, I guess to,
Why
the,
do we need two members from the domestic violence task force? Just curious. Is one is not sufficient?
well, it's, let's see, I'm only seeing one from the, Network Against, Domestic Violence. It's two from the state bar, but actually the previous amendment that the committee adopted, or the first one earlier, had two members of the state bar, being put on there, or.
Provide for the Domestic Violence Task Force, Maryland Network Against Domestic Violence.
And
Take out the Bar Association members.
And just for context, the first amendment that the committee adopted, one of those members of the state bar needs to have expertise in victims' rights. So that you know, I don't know how the committee wants to slice it, but you know, that's covered by the First Amendment. But obviously, if you'd like to add more.
I'm not sure when I proposed my amendment. I think it was before, Jamie, you drafted the one we adopted.
Right.
So to the extent that it references State Bar Association members, it's redundant.
Okay.
So I would take those out and just leave adding to the task force, the executive director of the Maryland Network Against Domestic Violence, or his designate. Does that make sense? With that change, can I move the amendment?
Is there a member of the defense bar outside of the public defender on there? And I'm not trying to belabor anything, but trying to make a balance. And I know that we refer to the public defender for so many things, but you know, in recent times, the Maryland MCDAA, the Maryland Criminal Defense Attorneys Association, has become more active, and there is sometimes a difference in philosophy between private defense bar and members of public defender.
Say that to the bar.
So the amendment, the first one that the committee adopted for the MSBA appointments, it wouldn't necessarily have to be private defense bar. It could be any member of the of MSBA who's a member of the criminal law section. So that's what that provides. But if you'd like to be more specific about it, we could do that.
Jeff and I also, we sort of have this same concern, I think, which is that adding two public defenders or two people on the defense side, I don't see anybody here on the prosecution side.
That would be, I think that would be important.
Well, the MSAA president or the president's designee is a member of the task
I
force.
got you. Yes. Okay.
Yeah.
Right. So we have somebody on one person on the prosecution side. Why do we want two on the defense side? Isn't one sufficient?
Maybe.
There's two on each side.
Unless I'm reading it wrong, from the First Amendment, we have the state's attorney association, and then an expert in the subject matter of criminal sentencing appointed by the state's attorneys association, then the public defender.
No, that was deleted.
Am I looking at the wrong amendment?
Right. It's if you're looking at I think the starting point, Senator, would be Amendment 753925.
If you look at the reprint.
Okay.
There's a lot of confusion on this. Can we hold this bill to have it like handled?
No, we're almost there.
We're almost there.
We're almost there, we're almost there.
Sorry, I was looking at the wrong amendment.
So, yeah, we've taken out the one that you were mentioning. It's been deleted. So at the moment, we have one person from the prosecution side and one person from the defender side. So it seems to me that should be sufficient.
So, all right, we're gonna go back to amendment 7832228/1. You've struck all of 13. And so you're just gonna go with 12. Is everyone okay with adopting that? So motion seconded, everyone's good. Okay. Let's go on to this last amendment. James.
So this, if you look at the reprint, this again pertains to the duties of the task force and what they would be studying. I guess given the earlier amendments that the committee had adopted, this might be tough to work in, but it was adding common law criminal violations. Okay. That's it?
And
Oh.
in as much as the First Amendment really reduces the parameters of the responsibilities of the task force, the original bill provided for a long time. It says that the report isn't due till December of next year. So I would make an amendment to change 2024 to 2023. That shouldn't take them longer than this year to do the work that we're assigning to them.
All right, now the bill is before you as amended. Is there a motion? Motions for favorable. Seconded. Favorable with amendments. Is everyone okay? Do we need a roll call? Everyone is good. All right. The bill passes. Wait for.
On 211, we can handle that quickly. Could we hold that for another week?
Yes.
I'm having a meeting next Monday to try to satisfy the judiciary's concern about the bill.
Excellent.
So,
Okay. Senate Bill 211 is held.
We have a half hour. Are we gonna be able to do 21 or not?
where's 21?
Which one is it?
21.
Oh, yeah.
Position of authority bill.
Yeah, are we holding that?
No. No, we got it. We figured.
Did we? Let's hear it. Who's got that? Okay.
Let me just pull up the note here. Senate Bill 21 expands the definition of a person in a position of authority under the fourth-degree sexual offense statute. The bill also expands the application of fourth-degree sex offense to include specified individuals. The bill establishes that unless specifically charged by the state, a violation of fourth-degree sex offense cannot be a lesser included offense of any other crime. There is one amendment in your voting packet that is Amendment 328. And if you go to page 3 of 4 in the reprint, what that does is it strikes lines 15 through 18 in the on the page. So what would be prohibited is that a person in a position of authority may not engage in a sexual act or sexual contact or vaginal intercourse with a minor who at the time of the sexual act contact, and in fact that should probably say intercourse as well, is enrolled or participating in the institution, program, or activity where the person in a position of authority is employed or under contract.
So this was the section of the bill that said even after the person in the position of authority no longer is in a position of authority, if the minor is still a minor, the person who formerly was in a position of authority cannot get involved sexually with the minor. So this strikes that part of the bill and leaves that open.
So, I know we've discussed this bill for a couple of sessions and, I want to support the bill, but I do have concerns about the bill and I've had them throughout. And I don't want to take us back to anything that we've already apparently, passed by, but what is the rationale for why we are even focusing on position of authority and defining it? I'm not comfortable with the broad category of position of authority because I think there are levels. But aside from that, why are we not just saying it's not lawful and there's a penalty for anyone that is an adult above a certain age for having sex with a child? What my point is, like, I'm caught up on how we are equating non-entrusted figures, non-governmental figures with governmentally trusted. Like a teacher is not the same, as I've said a million times, as, you know, a private contractual guitar teacher. They're not the same. And I don't agree that the level of trust that should be placed in them is the same. So I do struggle with that. But again, my broader question is, why are we focusing on this? Because it's my problem and not just talking about how adults shouldn't be having sex with children. Maybe that's a discussion that we can
Involved in
have.
the current law already provides that teachers cannot have sex with their students. So if we went to your formulation, Senator, we would wipe that off the books and say that a teacher who's 23 years old, who is graduated from college and got a teaching degree and is now teaching 17-year-olds, 23-year-old teachers can have sex with their 17-year-old students. We don't want to go there. So what this bill does is expand that prohibition to others who are older than the 17-year-old, 16 or 17-year-olds. And they're the only ones this bill's about. It's not about under 16, that's already illegal. So 16 and 17-year-olds having sex with someone who has some kind of a direct supervisory relationship over them and exploits that relationship in order to initiate sexual conduct.
That's better language, no doubt. The exploitation of the relationship.
Well, I actually have an amendment I'm going to propose that Senator Walczak and I discussed earlier.
For the record,
gets into that area.
I do think that when you relate this to other things and you equate persons that are not in parity with one another as if they are the same, a minister, a priest, a teacher, there is an inherent trust in those people, but there is not or should not be an inherent trust placed in the tennis instructor at the tennis court in the park, right? That is not the same. And I have a concern in trying to make them the same. I'm not saying I'm against anything about the bill, but I do not agree that they are the same or that the level of trust placed in them should be anything comparable.
Right. You and I had conversations about that offline. I'm not sure we're ever going to agree to disagree on this, with just a difference in approaches.
Should be age restrictions where generally and for the most part, adults shouldn't be having sex with children, whatever their role. So I just think that my problem with the bill is really rest in that making these people in parity with one another when they are not and should not be seen as the same under the law. And we should not be giving a message to the public and to families and parents that they are the same, because they are not the same.
Okay. Maybe we should consider the amendments, and because you're really objecting to the whole bill. You're not objecting to an amendment to the bill, right?
I think the amendment, as I understand it, makes the bill better and more palatable but I do not,
So
I
can we
did
get-
not agree with the bill as it came in, and I know there's been work that's been put into it, but I also struggle with hypocrisy in everything. And that's where I had a problem with making that, drawing that connection between people that should be entrusted and people who there's no legitimate or logical reason why anybody ought to trust them. These people aren't subject to background checks. Do you know what I mean? Like, there's no legitimate reason why someone would trust these people, and we should not be sending a message that they should be.
I understand your position. It's basically that in the case that was brought to us about the piano teacher who took the daughter of the husband, of her father into a soundproof room to teach her piano, and they did other things. And your view is that really the father is the one who ought to be blamed, not so much the piano teacher. I just think that's a different world than we're in. In these days, most people entrust their 16 and 17-year-old daughters to a lot of people who have responsibility to supervise them. And it's not the parent's fault if the supervisor uses his position to prey on 16 to 17-year-old girls. It's the person who does the preying. So, and that's what this bill is all about.
Sam, I understand what both of you are saying, and I understand your point as well. Is there an amendment that we could think about that you could hold that would handle your problem? I understand exactly what that is.
I didn't know, I knew that was on the list. I wasn't sure we were gonna move on the bill today. And I don't have an amendment today, no, and I'm not gonna ask anybody to hold the bill up if you're ready for it. I'm not ready for it, so probably not gonna vote for it today. But if I had more time, I would think about it. I would take a deeper dive into looking at what other states do and see if there's even additional language we could come up with. I have unreadiness. I think, there could be a little bit of PTSD for me with this, because so many times we kowtow to a movement or a specific group because we agree with them and we fundamentally think, the concept is good, but the language is everything. And I'm just not ready at this very moment to move on it. And so.
Yeah. If we could take a look at the, I know that National Conference of State Legislators, they had this concern as well, and they tried to handle it to make sure that someone who is a minister, who is a teacher, who is in that kind of supervisory capacity would be separated out from someone with no official anything who happens to be 21, 22, and they like someone who's 17 years old, and they get involved in a relationship because then they're scarred for the rest of their lives without any intent of trying to in any negative way, nothing in the intent of breaking the law and luring people over and over again. But it was an innocent relationship based on a minister who was 21 and someone who was 17, or a teacher, et cetera, which is what we really want to get at, I think. And if we could take a look at that, I'll go back and look at with the National Conference of State Legislators, because they did find a way to decouple.
That's thought so we have time for the floor, but go ahead, Senator Folden, and then
We're gonna vote.
I think, look, we're gonna vote on Tuesday and Thursday and or Friday, and we are going to vote this up or down on Tuesday. So like, I'm gonna give Senator Carter one more run at it.
Well, we keep prolonging this, and there's another time to get another run at it. You can bring your amendment to the floor. The reality,
So I
it's been on the
apologize for that.
list.
Yes, but there were constant discussions about amendments. And the last discussion I heard was that we were going to hold it. That is what I thought.
We have plenty of time.
I've never heard, maybe it's because I'm not in those room discussions, but I never heard anybody talk about holding it. I've heard about moving a bill that's on a voting list, and we have a pattern of this is for the safety of our children, period. This is about protecting them from people that are
Right.
predators.
That is exactly why we need to get it right.
I
And that's
agree.
all that I'm saying.
this
And we're
bill-
still early in session. We're nowhere close to crossover. This isn't going to be the end of the world. But I said it, don't hold it on my account.
Okay.
I don't
Mr.
think
Chair,
it's
I move
ready.
for a vote. Thank you.
Sorry.
And I'm going to explore every option and then I'll make a decision. I think we have the right to do that when we make a decision that's going to affect the lives in the future of thousands and thousands of people. And so I'd like to hold it till Tuesday. I'd like to also get with anyone else to look at what they did. How do we decouple that to make sure as best we can that we're not ruining somebody's life who had no intention whatsoever.
There's a motion on the floor.
We've been there.
Got it. So there's an open motion.
Second.
It's been seconded. So it's been a motion, I assume for favorable. You asked for a hold, I know, but there's,
I think he has amendments. We're going in that direction. I think he has amendments.
who has amendments?
Senator West.
Added on the floor.
No, I think the sponsor has amendments.
Chairman, I was hoping we could vote on amendments today and then if you want to hold the bill till Tuesday, that's your prerogative as the chair, it's my view, but let's get the amendments done so we know what the bill
No,
looks
no,
like.
that's fair. Hold on. Do you want to withdraw the motion to vote on the bill without the amendment? Okay,
People who voted. So
all right.
I'm moving the bill.
With you, and hold on. No, there's no amendment on top of the bill yet. So withdraw to adopt the amendment. All right, so you withdraw your motion.
Yep,
All right,
withdraw it, adopt
we're-
amendment.
We're clean now, just to be clear on the amendment that we're about to adopt. Jamie, can you rattle off the amendment one more time?
This is amendment 383-328 on page 3 of the reprint, strikes lines 15 through 18. And Mr. Chairman, I noticed going through this that it probably does need a technical amendment in line 11 of page 3. I think we just need to make the wording consistent. So that would be part of it as well.
All right, it's been motioned, it's been seconded, everyone's okay with the amendment? Amendment's been
I've got
adopted.
another amendment,
Oh, okay, Senator West.
second amendment. I'm doing this on the fly. I just had a conversation with Senator Waldstreicher this morning. This morning, we obtained lists of other states that have similar legislation. And there's a slight wording that we could change that we could make to this bill, which would bring it into consistency with some of the other states. So on page, and I'll get a formal amendment prepared before Tuesday, so we actually have it. But on page 3, where you have the dispositive language in C1, it says, except as provided in such and such, a person in a position of authority may not engage in a sexual act, sexual contact, or vaginal intercourse with a minor. That's the key language in the bill. So the amendment would change that key language as follows. Except as provided, etc. A person in a position of authority may not use the person's position of authority to cause the minor to engage in a sexual act, sexual contact, or vaginal intercourse. So that's the amendment. And Jamie and I can work out the exact language, but that's the amendment.
Got it. Senator Waldstreicher.
I want to speak after we adopt the amendment. if That's okay.
Oh,
Sorry.
we're not going to adopt that amendment yet. Because you want to draft that first, right? You want to adopt that right
He
now?
wants to adopt it.
Is that too complicated to adopt in concept?
Yeah, I think we might need to work on some details on just on the concept. It sounds like what you're looking to prohibit is somebody from enticing or attempting to entice a 16 or 17-year-old from engaging in those acts by virtue of their position of authority.
Yes, using the person's position of authority to cause the minor to have sex with him.
Hold on. That changes the whole language of the bill, the reason behind the bill, because it is implied, it is known by the position that you're in, that you are in a position of authority and should not. You don't have to overtly say, well, I am your coach and you won't play if you don't pay. That should never be in something for a victim to prove. It's on the person who's in the position of authority that by their responsibility to those that they are the custodian and caretaker of, to be the responsible one to not have that happen. So that amendment does nothing but make it it changes it. That's a horrible amendment.
Work on the amendment between now and Tuesday. See if we can't reach consensus.
And look, just again, being honest, look, run that by the state's attorneys too. Okay. Run that language by the state's attorneys. Sure, Senator James.
Senator West, not a long discussion, just how was that couched in other states as helpful? Just not a long
Okay, I'm looking at, there are two states in particular. There was, hold it. Tennessee says, the defendant at the time of the offense in a position of trust or had supervisory or disciplinary power over the minor by virtue of the defendant's legal, professional, or occupational status and used the position of trust or power to accomplish the sexual conduct. So it's used the position.
No,
of
I
power.
know what it's saying. I'll ask you later. I don't want, this is getting late. I got a question about why some states have done that, how that changes the bill, why it's a good idea, and who doesn't, but that's too much of a conversation
Okay,
for now.
we'll,
It's late.
we'll deal with it on
Yep.
Tuesday. Thank you.
So we got, no, there's nothing. So we're gonna vote on Tuesday. This will be the first bill we tackle Tuesday. And then Senator Wallstrecker, Senate Bill 37 will be the second bill we tackle on Tuesday. So a new list will be out on Monday, but let's get over to the floor. All right, that ends it.